Welcome to the show. I'm Mike.
Hey, I'm Maggie.
And we are Friends on Fire.
We're on a mission to get friends to talk about money.
So Maggie, it's been, I think you'd agree, like a little depressing recently the past few months. Economy's really bad. Coronavirus, lots of people losing their jobs. So today, I think it would be great if we discuss something a little lighthearted and fun.
Okay, what is that?
How to plan for your death.
That sounds super not depressing and very lighthearted.
Well, yes, it's actually kind of a morbid discussion, but there's really no good time to plan for this sort of thing. And so...
Well, actually, this is a good time where there's like a quarantine and we're, many family members and friends are facing, catching a life-threatening illness. It's a good time to plan for it, actually.
Yeah, good point. And you're at home and maybe don't have anything else to do, so...
Yeah, you might have some time on your hands.
So today, we're going to bring on an attorney to talk through the particulars of this, and we'll ask her some questions.
Yeah, sounds great. Hey, Mike, do you have like a will and your advance directive and all that stuff in place?
I do. I hired an attorney,
Okay,
which
like
was
a real attorney.
like a real
Not like
attorney.
your brother Sal or something.
No,
Sal.
no. My cousin Vinny.
Like your cousin Vinny.
I
forgot he was a real attorney.
No, I did hire an attorney and paid at the time a reasonable amount of money for it. But, at the kind of suggestion of my parents, who both of their parents are deceased and had to live through the end of their lives and their estate process, they insisted that I get this done and get it done correctly. So we went to attorney, we had a will, we set up a trust, and
you did that after you were married?
After we were married, that's right.
Okay, got it, yeah. Yeah, no, I like it. That's good advice your parents gave you, which we'll get into a little bit more why this matters for people.
What about you?
Yeah, so I, in my typical fashion, because I like to get up on my roof and try to clean my own gutters out if I can, I thought, who needs a lawyer? Like, I have a minor in criminal justice. I can figure this out. And I'm, just cheap on many things. And so I was like, well, I'm going to go to LegalZoom and take care of all this. And I was like recently divorced and went to LegalZoom, did it, got it notarized by some friends at work. And then I met someone, got remarried. We decided we should do things a little bit more official. And it was a little confusing with blended families. And so we did go to a lawyer, someone that a friend had used and recommended and was kind of had an office near where we live. And that's actually who we're going to talk to today, the lawyer that I use to do all of our estate planning.
Awesome. Can't wait to talk to her. Let's get her on the line.
Hi, Elaine. How are you?
Hi, Elaine.
Hi. Oh, you guys look so professional.
That's the first time we've ever been told that.
I know, yeah. It's just the fancy microphones, that's all.
Okay, great.
There's some topics, Mike, that we think professionals are much better suited to cover. And this is one of them with estate planning. So the good news is you don't have to hear Mike and I talk about estate planning. We've actually brought in a professional to talk to you today. And not just any professional. This woman is legit. So her name is Elaine Levine. She runs a law practice here in Atlanta, Georgia. So she's licensed to practice in the state of Georgia. But we just wanted to tell you a little bit about her. And then we're going to have a conversation with her about estate planning, which we hope is helpful to you all. So Elaine is, when I say she's legit, she's a graduate of Harvard College. She went to Yale Law School. Like I said, she runs a firm in Atlanta, Georgia that focuses on wills, trusts, probate, family law, elder law, etc. She has represented, hundreds and hundreds of clients over the past 26 years. She's incredibly involved in community. She's facilitated different classes at private schools. She's got a really, I hope, a background that you're very proud of, Elaine. And I know you also have 3 children who are very accomplished also, which I'm sure might be your more proud achievement versus all of the legal accolades over the years. So we appreciate you joining us, Elaine, and thank you for coming on the show.
Thank you. I'm delighted to talk to your audience.
So I think we can just kind of jump in, and I think it would be helpful to start, Elaine, with just explaining to people what estate planning really is and what that term means to you when you hear it.
Estate planning is the process of trying to figure out what you want to happen if something goes wrong in your life. Either you become disabled, injured, or you decline in your health or mental faculties, or you die. And so we prepare for the tragedies that happen, and we try to make sure that your life at the end of your life, or when you're injured, and your family's life continues legally in the best possible way.
So I think that is a great explanation and kind of dovetails into the next piece of, why is this important to people? Like, why should people worry about this and want to be, want to invest in making sure that their estate is taken care of?
Well, as our lives are getting more complicated, we have children and families that combine in many different ways. And we also have a lot of single people. When something happens, that is not the time to be looking for a lawyer. That is not the time to try to put documents together. First of all, you may not be able to because you've had an injury or a decline, or you may have died. And so the law in the state that you live in will take over and make decisions for you. And when you have your own documents prepared while you are confident and calm and are thinking clearly, you are the one that makes the decisions for yourself and ultimately for your family and your friends. So we strongly encourage people before they get sick or injured, and of course before they die, to work with an attorney that they feel confident in, to prepare the documents and then maintain that relationship over time so that if something does happen, you or your family can go back to that attorney and get help in implementing your choices.
So maybe you can walk us through what happens when someone becomes disabled or dies. What are the concerns or the challenges that people face? What are going to be the things that you want to specifically put into these documents to help mitigate those risks?
So let's talk about while you're alive and you have an accident or a decline or an illness, and you need people to help you, okay? So there's medical decisions. And when you can't make your own medical decisions, if you have in Georgia what we call advanced directives for healthcare, in some states they're called healthcare powers of attorney and living wills. If you have that document in place, it will serve three purposes. One, it will appoint the people who can make the decisions for you. Two, it will appoint the people who can advocate for you, who can be there in the hospital with you and say to the doctor, I want a second opinion, or say to the nurse, we haven't seen a doctor, and can look at the medical chart. And three, it allows you to specify when you want to be allowed to die with dignity. There are many different stages of dying, and you get to pick if you want the machines, the medications, the nutrition, and the hydration all to be stopped at some point in your life. You are allowed in most states to say, this is when I want to stop these things from happening. But if you don't put it in a document and you don't properly execute that document, then the hospital and the doctors will be required to maintain you alive for as long as they can. And many people do not want that. So we have three purposes. We want people to be able to make decisions for you. We want people to be able to advocate for you. And we want people to be able to stop treatment and sustenance for you. When you're injured or you decline and you're still alive, you also have to keep paying your bills and filing your tax returns and dealing with your employer if you're still employed. So we use a financial power of attorney to appoint the people who can step in for you to do all these financial matters, continue your investments, get your benefits, deal with your health insurance forms, file your tax returns, and most of all, pay your mortgage and your bills. So usually we appoint 3 people. Sometimes it's a spouse or an adult child or a friend. We usually appoint 3 successive people. So in case someone can't do it, because it's a big ask to have someone step in to handle your finances. They also open your mail and deal with your online presence and those kinds of things. So the financial power of attorney is very important. Those 2 documents, the medical power and the financial power, end the day you die. So once you have died, nobody can act for you. That is a will or a trust that will step in and then specify what you want to happen after you have died.
So you mentioned the financial power of attorney. And one of the things that I'm curious about is, how does a legal financial power of attorney document executed through an attorney differ from one that might be filed with a brokerage firm? So my dad had financial power of attorney over me when I was younger and after I was 18, so he could manage my assets. I have one with Charles Schwab, so I can manage my wife's and have access to her account. Does a legal financial power of attorney document supersede those, or how are those similar or different?
Most financial institutions, I think all, have their own form. And I do suggest that if you do a lot of work with one financial institution, that you fill out their form. But that will only apply to that company. And it will not address opening your bills, paying your bills, filing your tax return, dealing with your employer, all of those things. That will only govern what happens with that financial institution. So a financial power of attorney prepared with an attorney will give your agents access to a much broader and more comprehensive set of tasks that need to be done for you with many institutions.
Just to follow on with what Mike was asking, if you did fill out one of those documents with your financial institutions and it was in conflict to what you had written in your will, which one kind of wins or supersedes?
That would be cause for a lawsuit. So you don't want to do that. You want
them to
careful, yes, that
Okay.
they match. Now, some institutions have very specific rules, and they will apply their own rules, even if they conflict with your financial power. But that's not a good situation. So you want to be very consistent with the people, especially, that you name. So you don't want a different person on your Charles Schwab account from the person you've named in your financial power. You're setting up a lawsuit.
Okay, good to know. And so we'll come back at the end for everyone and kind of recap all of the documents that you're talking about and put them in the show notes. But one thing that I think is worth just clarifying for people, because you just started to kind of talk about what happens if you were to get sick and up until a death, and then started to say, if someone dies, then you're dealing with wills and trusts and that whole situation. Can you kind of get into wills and trusts a bit to explain what the difference is between the two, how they work together, et cetera?
Yes, every state has its own set of laws that apply to what happens after death. And you have to be very careful to hire an attorney in your state, someone who is well-versed in estate planning, wills, and trusts, because you don't want someone who primarily does family law. They will not know all of the inside, intricate rules and regulations that apply. And I really discourage people from using an online will package like LegalZoom. What we do is we ask 1,000 questions of our clients, and we try to understand their family situations, their desires, their plans, and that's what an attorney is supposed to do, and then tailor the answers in the documents. When you do your own will, you are not asking yourself the right questions, and you're probably going to ask yourself about 1/20th of the questions that need to be asked. And so your document will be very, very narrowly tailored and won't have, I've looked at dozens of clients who've come to me after they've done their own LegalZoom wills, and they are always amazed at how different a real will is with an attorney.
Yeah, I will say I'm glad you spoke about that, because it's one of the things that, we wanted to talk about. We spend a lot of time on here talking about, how to save money, frugal living, saving for the future, etc. And I'm actually a personal testament. Elaine, you have a ton of clients, so you may not remember, but I had done my wills and my kind of full package, advance directive, etc. When I was recently divorced. I had done it on LegalZoom, and I don't know, I probably paid $50 or $100 for some package. And I remember getting it notarized at work and, having to ask some random people at work to notarize my wills and stuff. And I thought oh, I'm okay. And then when I was getting remarried, we thought we should just go get all of this kind of taken care of together. And we had heard of a friend that had used you, Elaine, and we went to you. And I'm a pretty cheap person, was my point, right? I like to save money. I like to DIY and, do things myself if I can. So I was, proud of my first attempt at LegalZoom. And after talking to a friend, I was like, I think I can afford to go see a lawyer. I should go probably do this more legit. And you are totally right, Elaine. When we went and talked to you, I remember thinking, oh my gosh, I didn't get asked any of these questions by LegalZoom, right? This wasn't in their forms. The sort of scenario planning you went through, how you asked us a lot of questions about what was important in life and how we wanted our children raised, of some, just all these things where I had not thought about it. And then I think the other interesting note is just the level of scenario planning. It's a little bit depressing at times. I remember thinking wow, this is really deep, that I have to think about if these three, if I die, if my husband dies, if my brother dies, if my mother, it's you think of all these scenarios. Well, what if this person's no longer around to do the task? Who's your backup? Who's your backup to them? So I just will attest that I found it to be a very thorough process. And I was just opening this. You send annual check-in to re-review your documents to clients to think through. And those are the sort of things where it really is top of mind. And anyways, I can attest to, as someone who is very frugal, was well worth the money and the experience to do it right. And I felt very good about how we went about it.
Thank you. And you brought up an interesting and important point, and that is that very often clients come to us with old documents, not just LegalZoom type documents, but they'll bring in wills that are 20 years old, and they're completely wrong, out of date. They name people who have died. They name people who they don't speak to anymore. They name guardians for babies, and now those children are 18, 17 years old. And so we are very unusual in this. Most lawyers don't do it, but we send out a letter to every active client. This year it'll be close to 500 letters, telling them every year what choices they made in their documents, because it is increasingly important to review every choice you made, because our lives are just so different than they were 5 years ago, 10 years ago, 20 years ago. So if your lawyer doesn't send you a letter, you need to get your documents out and review them once a year. But every state is different. And in some states, the probate process, which is what happens after someone dies, is terrible. And so lawyers work very hard to avoid probate, meaning they avoid trying to have a will go through a court process. In Georgia, we have an excellent probate process, and we try very hard, or at least my firm does, to go through the probate process when someone dies, because we take the will to the probate court, we file it, and then the executor gets sworn in as an executor, a fiduciary. They are now acting in the best interest of the estate. And then they pull all the assets together, pay all the bills, transfer assets to the appropriate beneficiaries, set up the trusts that need to be done, file the tax returns, and eventually they close the estate. And it takes anywhere from 6 months to 2 years in most cases. And at the end of the case, the court issues an order relieving the executor of all responsibility and all liability. And that order is crucial. Our process in Georgia for the filing fees it costs about $500, and for the attorney fees, it's usually $2,000 or $3,000. But at the end of the case, everything has been done right, and everybody can move forward. Now, in some states where they want to avoid probate because there's a death tax, we don't have a death tax in Georgia, or there's a very long and expensive probate process like California, they try very hard with their clients to put everything in a revocable trust during the lifetime of the client. Once that property is owned by a trust, then the trust agreement governs what happens, and it doesn't ever go into the probate process. The problem with the reason we don't use that is, first, we don't want to avoid probate in Georgia, but also clients are very confused very often with that trust, and they don't get all their assets into the trust. So you end up with both a probate process and a trust process. And so in Georgia, because we have no really good reason to do a trust during the person's lifetime, we don't usually do that. There are some exceptions, especially for people who are becoming feeble and elderly, who we want to move out of the property, out of their control, before they can't manage it properly. But most of the time, we use trusts after someone dies. So if a young couple has a couple of young children, in their wills, they may choose to give property to their spouse first and then put it in trust for their children until their children are old enough to properly manage and use that money. And I'm not talking 18. I'm talking about 25, 30, 35, 40 years old. And we're increasingly seeing that spouses also, or partners, also want to put money in trust, even though they want the money used for their spouse. So let's say we have a man and a woman who are married, and the woman has and the man have about the same amount of money. But they're in their 40s, and they don't want, if one of them dies, they don't want the money they've earned to pass directly to the spouse, because the spouse may remarry and acquire a new family if the first spouse dies. So they very often now we're seeing couples put money when the first spouse dies into a trust for the benefit of the other spouse and those two children that they have together, but not for the benefit of any future people or creditors who might arise after the first spouse dies. These are the kinds of discussions you want to have with your attorney. What trusts might be helpful? What trusts might be protective from creditors and future spouses? And what trusts might be helpful for the surviving spouse in the form of a co-trustee? So there's lots of different reasons to do different trusts, and that should be discussed with your attorney when you draw up a will.
And so, speaking of when you say, that should be discussed with your attorney, walk us through kind of what the process looks like. Like if someone comes to you and says, hey, Elaine, I want to do, the full package. I want to make sure my estate is taken care of. What does the kind of high level process look like that they would go through with you?
So in our firm, we usually talk on the phone with the client just for a few minutes. Then we send out a first package, and it will have some forms to fill out, but it will also have 2 pages of questions for the person or the couple to talk about or think about before our meeting, because there's a lot of issues that are going to come up, and it's very good to start thinking about who do you want to be your executor? Who do you want to be your trustee? So those kinds of things. And then the client will, in normal times, come into our office, but now we are doing Zoom meetings or FaceTime meetings. But in normal times, they will come into our office and we'll have a 2 or 3 hour meeting where I will ask question after question, and the clients will tell me what they're thinking. And we talk about the will and trust. We talk about the advance directive for healthcare We talk about the financial power of attorney. We go through what they own, all of their assets, a home, maybe a retirement account, a life insurance policy, investment accounts, businesses. We talk about how each property is owned and how it would pass, whether by beneficiary designation, by co-ownership of some sort, or by will. We talk about their liabilities, their debts, and then we talk about all the choices they want to make. And we usually take it through several steps. So if this person is not alive, who should get it? His children or her children? And if they're not alive, who should get? So we do all of that, and then we decide who is also going to have copies of these documents, and we set a signing date, usually for a month or 6 weeks later. Then the clients will get drafts of everything to review, and they're long and tedious, and we apologize, but they have to be. And then we talk on the phone and go through everything. We usually email back and forth many times, so any decisions that aren't made will be made. And then finally, the clients sign their documents, which in Georgia must be signed before 2 witnesses who are not named in the will and a notary public. And they all must be in the room at the same time. We do have an emergency order right now from our governor, and many states are doing this, which allows us to do video conference will signings during this emergency. And so we are continuing to sign wills and documents, but the witnesses, the notary, and the clients are all participating on a video conference like Zoom.
That's so interesting.
Yeah, we can watch each other, and then we scan and email it to each other, and everybody signs. It takes about an hour and a half, where a normal will signing will take 30, 40 minutes. But it's working, and we're very happy to be able to do this, especially for people who are quarantined right now.
Yeah, that's so interesting. Are you required to keep a copy of the video? Or is it just that you need to see each other?
No, we just need to see each other, and then we find that we are seeing each other do that.
Okay, got it. It's interesting. It's nice that there's been some adjustments made.
Yes, it's crucial because we have several people. We have probably 5 clients who have the COVID virus and are not able to leave their homes and are afraid of dying and incapacity. And so we have to move forward as quickly as we can.
Are you seeing a lot of uptick over the past few months of people wanting to get their paperwork together, just given COVID and the sort of fear it creates?
For 3 weeks, we got no phone calls because I think everyone was in shock and didn't even know if we were in the office. We are actually working from home, all of us. But after 3 weeks, we started to get new clients who wanted these documents done, but we also started to get a flood of questions from existing clients saying, are my documents okay? Is everything okay? And they are. They're good. I wrote them. But there's a panic and a tension in people, and they want assurance. And that's what we're here for, is to offer. We answer questions. We offer assurances. We walk them through what their choices were to make sure they're still right. And usually the clients are very relieved, and sometimes the clients want to make changes.
So Maggie mentioned that she did her first will on LegalZoom and for $50. And I think a lot of people would probably, when they think of attorneys, they think of large expenses. And so what can someone expect to pay, generally speaking, for these types of services?
Well, that's a loaded question because every place is different and every attorney is different. So I can only really speak for Atlanta, Georgia, a big city where we have a lot of attorneys. I have 36 years of experience, so my fee is higher. But I also have a wealth of, I hope, wisdom, and also I've watched things change over the years, and I know the context of what people are dealing with. My fee to work with a couple to do all of the documents, and then they get annual letters every year, my fee is $2,500. For a single person, it's $2,000, which is not half of a couple's fee because it actually is about almost the same amount of time because you have the same number of meetings. My colleague, my partner, Elizabeth Lawrence, has 9 years of experience, and her fee is $2,000 for a couple and about $1,700 for an individual. And then, of course, if we do additional services, it costs more. So we might, if we do an extra trust, or if we do a warranty deed, or if we do, an extra type of trust for retirement planning, those kinds of things, there'll be more involved.
Yeah, I think that's helpful. I appreciate you sharing just some examples of costs, because I think it's helpful for people to know who think, well, I don't know if it's $200 or $2,000, right? Just to get a sense that, it sounds like it's typically, a couple $1,000s to a few $1,000s to really hire a lawyer that specializes in this area, to your point, to do this the right way, which again, I can attest as someone who is very frugal, that I decided to invest in that. And it's definitely something that I've been happy with, and feel very confident that my family's taken care of, my husband's taken care of. We've kind of gone through all this scenario planning, and it's super helpful.
And the other thing I wanted to mention is that we spend about 10 hours per family to do these documents. And so if you think about the hourly rate, if you have a lawyer that's offering to do this for $500, they're not spending 10 hours. And it takes 10 hours to have the meetings and do the drafting and change everything and go through everything properly. And so if you're spending less than $1,000, you're probably not getting the attention you need to the documents.
One of the things when I'm like notoriously frugal, and when I decided to hire an attorney to do this paperwork for me, one of the things that was on my mind was that it was going to cost a couple $1,000s initially, but the risk I was avoiding for my family might be tens of thousands, if not hundreds of thousands of dollars in the future. Can you kind of explain what some of those risks are if you don't go through this process very well?
Yes, our goal when someone passes away is that the family stays as close to each other before the death as after the probate process is complete. So your biggest risk is that you are leaving your family with internal strife, angry people who will never have a relationship again, lawsuits, difficulties transferring property, bills that go unpaid, and mortgages that are foreclosed. All kinds of risks are there. In addition, when you have blended families, a couple that each has their own children, you are risking that some of those children will get cut out or treated differently than the other children. There's a huge amount of risk when you have children in a family who are not adopted by the second parent. And most of the time, the second parent is not allowed to adopt the children because there's still a living other parent. And so even though the family may be growing up together, if there's a parent that dies, you're going to have huge risks without a proper will that those children won't be treated the way the parents want them to be. So there's all kinds of problems. Real estate is a huge problem. If there's not a proper will and you're trying to pass the home on to a family member or get it sold, you have to have the proper paperwork to make that happen. And so what you are investing in is the peace of mind of knowing that hopefully, if the documents are done properly, if you die at the end of the probate process, your family will still be close, will still love each other, won't be angry, and can move on. The other risk that you're avoiding is if you're injured or you decline mentally or physically, you don't want your family to have to go to court for someone to be appointed as your guardian and conservator. The documents that we prepare are designed to avoid the horrible process of telling the probate court all of the intricate family secrets that require you to get that guardian or conservator appointed. Usually, if it's a person who's had a brain injury in an accident, you have to bring in psychiatrists and doctors and psychologists to testify that the person is not competent. And that's a very, very stressful and expensive process. If you have appointed a medical agent and a financial power of attorney, you can begin to act for that person without going to court. And eventually, if the person is has permanently declined, you may need to become a legal guardian and a legal conservator. But most of the time, we are able to use the documents that we have prepared with our clients to allow the family members appointed to take over when needed and then back off if the person recovers.
That is super helpful. Elaine, you've talked about a number of documents, and we'll put these in the show notes, but can you just sort of briefly recap the core documents that are part of an estate planning package? And you've talked through a lot of them today.
So the first one is a will, and in some states you will also have a revocable trust. In our state in Georgia, we use the will to set up trusts, so you can usually just have the will. Then you want an advance directives for health care, sometimes called a health care power of attorney. And then you want a financial power of attorney. Now, we also do a HIPAA authorization, which allows the person who's your medical agent to get access to HIPAA-protected medical records. But a lot of lawyers don't do that document. And then finally, you need to be very focused on the beneficiary designations for your life insurance and your retirement plans. So that, because very often you specify who will inherit those assets and it won't go through your will. So you and your lawyer should go through exactly how every asset should pass using change of beneficiary forms for retirement plans, annuities, life insurance, and even investment accounts.
So that's a great point, just in case people didn't catch it. And I want to make sure I even caught it for myself, is you were saying that, all of the beneficiaries for like life insurance and brokerage accounts and your retirement accounts, et cetera, those actually need to be dictated with each of those individual companies.
Well, it depends. If you don't have a beneficiary listed, it will come into your estate. And many times that's fine. But a retirement plan under the IRS regulations and the law may be rolled over to certain beneficiaries, but only if you've listed them on the retirement plan's book. So that is a change of beneficiary or a designation of beneficiary. Now, investment accounts usually have an owner, and sometimes they have a beneficiary, or it says TOD, which is transfer on death, or it says POD, which is pay on death. In that case, if you have listed somebody as either a co-owner or a POD or a TOD or a beneficiary, it won't go under your will. It will go according to that listing of who you've named. And very often people forget that they've done that. So you'll get somebody who got divorced 15 years ago and they still have their first spouse on there. And after the person died, second spouse says, well, wait a minute, that he didn't want that or she didn't want that. So you have to be very careful that the people you've named for all those types of accounts and policies and annuities will actually be the right people, and that you actually want it to pass that way and not through your estate.
Yeah, I think what you just explained in that answer, Elaine, is one of many reasons why I'm a big proponent of hiring a professional to help you with these things, because there's a lot of complexity to it and there's a lot of nuances to it. And this is why people go to law school and practice for, decades. And so again, as much as we are DIY in many areas, this is an area where we actually do recommend that you consult with a professional and hire the right professional for you in the right state, et cetera, to help you, because it's worth the investment, we believe. You've talked through a few of them, Elaine, but what are some of the more kind of unique circumstances and situations that people might need to adjust for, like blended families, et cetera?
Yes, blended families is one thing. And what comes up very often with blended families is what happens to the house when one spouse dies or one partner dies. Because you may have kids from both sides, and you may or may not want that huge asset that you own to be held in limbo because the surviving spouse wants to live there. And if you intended for the equity in your home to go to your own children, are you going to accommodate your surviving spouse living there? So those are the kinds of questions you need to deal with. We also have families with special needs children, young people and adults, and those need to be considered very carefully so that we do not jeopardize their federal and state benefits that they're getting as a special needs person. We also have elderly couples who have elder law needs, where they are also trying to decide where to live, what kind of community to live in, and who to trust, and those kinds of things. So we work with the elderly. And we work with same-sex couples who are married or not married, who sometimes, unfortunately, have families who do not support their lifestyle. And we have to be very careful to make sure that we're very, very clear on what the couple wants to do, so that an angry family member does not intervene if someone passes away. And finally, we have lots of people with small businesses that they own, and we have to look at what will happen to that business if the main person dies, the main person running it dies. What will happen to the employees and the continuity of the business. So we look at all of that. And then the last thing I want to mention is that if you own property, real estate, that is not in your state of residence, you have to be very careful and need to talk to the attorney about what to do about that, because unfortunately, we can't do the probate of an out-of-state piece of real estate. So we actually have to open a probate case in that other state. And if you own property in 5 different states, you're now multiplying the cost and the complexity. So there are ways to deal with that without opening probate cases in every state, but you need to talk to your attorney about that.
Well, this has been fascinating and extremely helpful, I think, for everybody listening. And I appreciate you discussing a lot of the nuances and importance of this information. Now, before we let you go, we have one fun thing that we like to do at the end of the show. Maggie has this thing she calls Mike's Minute on the Mic, and she asked me some weird question to put me on the spot, and she gives me 60 seconds to answer it. So we have Elaine's Minute on the Mic today. What is the craziest thing you've been asked to put into a will or a prenup?
I have clients who have a very special pet, and we did $1 million pet trust for that pet that required that the pet sitter move into the home, live there, that required the veterinarian to come to the home once a week, paid, obviously, that required that all the medications be certified to have been given every single day, and all kinds of requirements for this one pet. But at the end of the trust, at the end of this pet's life, any money remaining in that trust was going to be given to the Humane Society. So I felt okay about doing this $1 million.
That's very nice.
But that took me a long time to get drafted and negotiated with the client and get it just right.
That's a great story.
Interesting.
I like that.
I know. I'm not sure I put that much thought into what happens to the money going to my own children. So they put a lot of energy in the house sitter and the vet and all that. I love it. I'll say one more just sort of quick thing, which I briefly touched upon earlier. Elaine sends this letter every year, and I will admit, Elaine, that this came in July of 2019. I just opened it at the beginning of this call. It's been sitting on my desk like in a pile of just sort of longer term to-dos. Like I knew it wasn't going to be a simple thing. And I opened it, and it it really is helpful to look at decisions that we made only, I think, maybe 3 or 4 years ago that I'm already like, ooh, why would I have done that? We don't talk to that person anymore. Like, we were close with them 4 years ago, but we've not spoken to that person in 3 years. And so perhaps I shouldn't leave my children with them as a, third backup. And so I just think it's interesting. Like, you might think a lot of this stuff really sticks over time, but the process of kind of reminding yourself what decisions you made, 1, 2, 5, 10 years ago is actually quite helpful, because I've been scanning this morning and thought, I actually want to change some of these things. And, I'm not sure why I made that decision 4 years ago, but it's not the decision I make today. So I think it's also worth just reminding people, as important as it is to get these documents in place, there's some value in keeping an eye on them over time, in the same way that you would do with all of your personal finances. And, you're constantly kind of checking and monitoring them and adjusting them to your lifestyle.
I would also add that you now have about $150 of podcasting equipment, which if you were to die, I'd be devastated, but I would like that back.
You'd like it back. Yeah, it's funny, when Elaine was talking about small businesses, I was like making eye contact with you. I was like, what are we going to do with Friends on Fire? We have nothing in writing about this, quote, business. It's not actually made any money yet. So, but yeah, I'll make sure when I update my paperwork with Elaine that I literally put a note on there of FOF, and I was like, yeah, I'm going to bequeath Mike all of my half of the podcasting equipment.
Thank you.
If something happens.
Very good. And I didn't mention this, but sometimes personal property, the things that you can touch, is even more important to some people than the money that they're passing on. So we are very careful to designate who gets all the personal property, the cars, the furniture, the clothes, the memorabilia. And the pets. So that's another thing to discuss at length with your family.
Yeah, pets is a great point. This has been incredibly helpful. I hope our listeners, or I know our listeners, will find this to be valuable, because I know this category of, life planning is often one that people put off and think, oh, I know I talk to a lot of people getting married that are always like, oh, I know I need to go do, joint wills and all this paperwork. And they just, years can go by where you kind of put it on the back burner and don't take care of it. And it definitely is a really good feeling, just like with all the financial topics we talk about. I think getting your paperwork in order and getting an estate plan in order is such a good feeling, because you know that you've done, everything you can do to take care of your family if something were to happen to you, and to make sure that the right things go to the right people and happen in a way that, would make you feel good and happy. So it's something we definitely recommend, and we really appreciate, Elaine, you coming on to just kind of walk people through a little bit of what they should think about, what the process looks like. So it's super helpful, and thank you so much.
Thank you for having me. I've enjoyed it.
Awesome.
All right. Thanks, Elaine.
Okay. Bye.
All right. Thanks for listening today. If you have any questions or comments, you can always give us a call or text us at 404-981-3370. Love to get a question, comment, or tip, and we will play it on the air.
Awesome. You can also follow us on Instagram or Facebook, and you can find those links on our website at www.friendsonfire.org.
Please subscribe and leave us a review on iTunes, wherever you listen to this podcast. It really helps other people find our show.
Okay. Thanks, Mike.
Thanks, Maggie.
Bye.
Bye.